Who is it talking to? This particular provision talks to which court? Huh? Yeah, it's domestic law of what state? Is it state A or state B?
State A.
You know how we always talk about these states, state A and B, now we know that. State A, state B, this is a court of state A, state B. When you read Article 2.1, and the case is actually filed here, and Article 2.1 is talking to who? State A, right? So if the state court, state A, finds that the subject matter of the agreement is not capable of being settled by arbitration, state A, the court of state A, is not compelled to do what? To enforce the arbitration agreement. That means they can decline to enforce the arbitration agreement in a adjudicated case. That's how it always arises. That's how the question is always presented. So, when Mr. X initiates a legal action in state A, and this guy, Mr. Y, comes before state A and disputes the validity of the arbitration agreement, they could do so on the basis of many things that we talked about before, right? I didn't sign it, it's forged, things like that. It was a function, it's a product of mistake, undue influence, duress, waiver, things like that. This time, the defense is completely different. It could say, I understand, yes, I signed the agreement. Yes, I knew what I was doing. Nobody forced me, there was no forgery. However, the subject matter of the agreement is incapable of being arbitrated. You cannot agree to arbitrate certain subject matters. So what are some examples that are indicated in your textbook of subject matters that cannot be subject to arbitration?
Violate public policy.
Public policy, yeah. What are the, like, list, give me names of, like, what subject matters?
Women.
Things like that, exactly. Now, where does that list come from? Usually, in this case, this judge should be looking at one law to see if the subject matter is capable or not capable of being arbitrated. Exactly, its own laws. It's asked to enforce an arbitration agreement, right? The court that is asked to enforce arbitration agreement can say, under my laws, you cannot arbitrate child custody matters. Why are you before me about arbitration? I will adjudicate this, or I'll send it to the family court or something like that. So they decide on the basis of their own law to see if that particular subject matter is capable of settlement by arbitration or not. So each state would have a different list. Sometimes those could overlap, but you have to look at that specific state's list of subject matters that cannot be settled by arbitration. In the old days, many states, including I think China, contained provisions that said a subject matter, a contract involving an administrative agency is not capable of being arbitrated. Like if one of the parties is a state-owned agency, they were not permitted to arbitrate. They have to go to court because it's their own court system. Many countries contain that kind of provision. Those are becoming extremely uncommon now. All right, so that is really the source of this whole discussion. That is Article 2.1 of the New York Convention that carves out a particular set of subject matters that cannot be settled by arbitration. When the states signed the New York Convention, they wanted to keep this discretion for themselves. Let us be the deciders or the decision makers on this particular. But once we permit arbitration on subject matters, then we shall enforce it. Just like this. So let's explore the most commonly carved out exceptions, subject matters, in various jurisdictions, and mostly from the United States, the European Union. We have the Wilco case, it's an old case, 1953. We'll see how the analysis there is conducted. An EU case here, and then a couple more U.S. Supreme Court cases, and ECJ, and Circuit Court of Appeals. Okay. Now, in Wilco, this is, by the way, a domestic court case, but the principles are the same. So that's why we're looking at it. 1953. What was the subject matter of the arbitration? Sale of shares, right? Now, when you buy a share on the stock exchange, on the market, open market, do you know exactly who is selling that?
No.
It's complicated, right? When you go out to a store and buy a pair of gym shoes, you know exactly what you're getting, right? You try them on, and you know the guy. You pay the money, you get the product. Very simple, straightforward, arm's length transaction. The relationship between the two of you is what? The legal relationship is purely contractual. Exactly. It's an arm's length transaction, it's contractual. The contract simply says you pay him a certain amount of money and he gives you the shares. If you fail to pay, he's not going to give you the money, the product. So you know exactly what you're doing. If something happens in between, like he gave you the wrong size and he refuses to return it, maybe you can sue that individual. Say, our agreement was for him to give me number 42. Now he gave me 39. I can't even wear them. But if you buy stocks and you don't even know who is selling those things, you don't even know how much they are tomorrow, and that's probably why you're buying them in any case. And now, most things these days are traded right on the stock exchange. That's how we operate. Because of this uncertainty, states make their own securities laws, right? Securities laws are designed, some of you might have taken some securities laws, are designed to protect the consumer from the sellers. The sellers are people who know exactly what they are selling. The consumers need protection. Now, the question in the local case was whether or not a securities laws-based cause of action is capable of being arbitrated. Right? That is the fundamental question in this case. Now, the party that is arguing for court litigation rather than arbitration, what are the benefits of relying on the securities laws that they are arguing? How do the securities laws protect the consumer more than simple contract law?
Evidence. The
How?
burden of evidence is on the seller to show the mind proving the mind of evidence.
Yes, so that's absolutely right. It has to do with burden shifting, right? If A is suing B for breach of contract, A has the burden of doing what?
Claim.
So that a contract existed, yes, and then
breaking.
yes, and then B breaches the contract, right? It's only after A has carried her burden that the burden would actually shift to B to show why B is not performing, right? And if B has valid reasons for not performing, she must present evidence showing here is why I am not performing according to the contract. But under securities laws, if you buy securities, shares of companies, and there is misrepresentation, they told you that it's worth $100, then you buy 100 of them. Later on, you find out that there's some concealment of a material fact. In fact, the price of that was probably $20, so they misrepresented, they cheated you. And that is what you're saying here. You should give me $10,000 back because you misrepresented when you sold the securities to me. Now, ordinarily, A would be required to show that B misrepresented, right? That's how you carry your burden. But under the securities laws, they shift the burden to B, and they actually tell B to do what? To show what? There is no scienter, yes? That is lack of bad faith or misrepresentation. It's like asking someone to prove his innocence. You accuse him of wrongdoing and then say, well, show me how you're innocent. That's really what the securities law does. The absence of scienter, oh, I might have given you that information. I gave you that information in good faith. I had no intention of misrepresenting the facts. If he can prove that, then he carries his burden, and that burden shifts back to you to show that, regardless of the evidence that this person is presenting, there was some misrepresentation or some bad things happening. See? So this cause of action arises out of, so when you present a contract dispute, a breach of contract dispute, what you're doing basically is that there is a contract that says X, Y, Z. B failed to do those things in breach of contract, and that's the end of inquiry. And maybe you rely on contract law that says if you breach contract, you must compensate or whatever it is that is. But in this case, what happened was not a reliance on simple contract law, but the cause of action arose out of the securities laws, and securities laws are public, designed to protect the consumers. So when in a contract you say, if there is a breach of contract, you shall arbitrate. The question is, does it also include a cause of action that arises out of, not the law of contracts ordinarily, but a public law that is designed to protect the public generally? That was the question that Supreme Court was looking at in this case. You might have noticed in this case that when securities laws are violated, so you can have different causes of action, right? One, breach of contract. Number two, There is also addition. And the question is whether or not the arbitration agreement pertains to both. It's a simple breach of contract, then it can go to arbitration, no problem, unless the arbitration agreement has other kinds of defects. But if it adds something that was not anticipated in the agreement, should it also be a subject of arbitration? So what does the court say in this case about that?
This right cannot be waived. And because consider the legislative purpose, they want to protect the consumer. And if we let this litigation on the arbitration costs, arbitration tribunal, then maybe the consumer will be not so well protected. And the review of the award of the arbitration is very limited. So consider all this, we should protect the consumer. So the process, it violates the public policy, it violates the security law. So they don't allow them to go to arbitration.
Yeah, that's the outcome of this particular case. That's exactly how they analyzed it. It has a greater purpose than just protecting one consumer. It's a public policy. It is designed to protect everyone. So we cannot allow arbitrators to be determining cases pertaining to this very important public policy matter. And of course, related to that, if arbitrators make a decision on it, then the level of review that the courts are going to conduct, that the enforcement state is going to be very limited. These guys are not equipped to adjudicate public law matters, and therefore they should not be allowed. Now, if, however, the parties expressly agree that we shall arbitrate all public law matters, can they do that under this case? Not only disputes pertaining to breach of contract, what if they actually say we will? What if they specifically say we will arbitrate breach of contract claims, we will arbitrate securities laws claims, we will arbitrate everything? Can they do that?
No.
Why not?
Because the law comes in to arbitrate a claim that is not capable of arbitration.
Exactly. So that's the point. So this subject matter under the law is not capable of being settlement by arbitration. They can't. Even if they wanted to, they cannot waive that right. It's a waiver of right. It's a waiver of right that's given to you by public law. And of course they're telling you, you cannot waive those rights. Why? It's not only intended for one particular individual, it's intended for the public at large. So arbitrators stay out of that. It's basically trying to protect consumers in this case. If you look at the second paragraph, the last sentence of the second paragraph on page 477, and it says the security buyer has a wider choice of courts and venue. He thus surrenders one of the advantages of the act, the advantages that the act gives him, and surrenders it at a time when he is less able to judge the weight of the handicap the Securities Act places on his adversary. So the two guys that are arguing, right? One of them is the seller, the other is the buyer. The law intentionally prefers the buyer and places a lot of burden on the adversary. So if you say we're going to arbitrate and waive your right under the securities laws, it is a waiver, and they say you waive it at a time when the handicap on the adversary is really not very evident to you when you buy those stocks. So the idea is courts would provide better remedy incomes, and so you would have a lot of choices of courts, venue, things like that. You give up all that option, all that opportunity when you actually make an agreement to arbitrate. So they say, no, we're not going to allow you to do that. Under the FAA, courts could actually review the final award, but they're limited. This is also it's not without controversy, but whenever they do, they only review arbitrators' decisions for manifest disregard of the law. It has to be very clear that they have disregarded the law. Any kind of error, the court would not have the opportunity to correct. Therefore, when it comes to these kinds of cases, let's just make sure that it was decided from the very beginning. Arbitrators should use that. Do you think this decision makes sense? Does it unduly restrict party autonomy to engage in signing an arbitration contract? Why is it that arbitrators are not capable of adjudicating the burden shifting things? Why don't you let them, give them the law, and tell them the burden shifting scheme, and let them determine? What's the problem with that?
I think there is the imbalance power between the seller and the buyer. So the seller is likely to force the buyer to waive their right to arbitrate the issue.
Yeah, but why are courts better than the arbitrators in deciding the lack of scienter?
Maybe the arbitrators are nominated by, although both parties can nominate the arbitrators, the sellers are more experienced, I think. So
yes.
The sellers can take an advantage in the arbitration.
Yes, I think that's it. That's probably what the court is thinking, right? Sellers are repeat players. They know. They send it to the public. And they want them to take these things to court rather than actual tribunals. But there isn't anything inherently difficult for arbitrators to be adjudicating a case on the basis of a public law. What it does is shifting the burden. If these are people who know how to adjudicate things, they can deal with it as much as any court could. But the court says in this case, it not only limits you to particular arbitrators, but the venue, for choice of the court that you want to go to. If you are free of arbitration, there's many options that you have, and we don't want you to limit. We don't want to limit you as to what kind of options that you have to specific means of resolution of this dispute. So that's really what they're saying in this case. Now, again, this is back in 1953. At that time, courts were, in the United States, courts were very suspicious of arbitration. Very, very suspicious of arbitration. It wasn't until they decided, the Supreme Court decided, the Mitsubishi case in 1985, that they really became so pro-arbitration, and since then they never stopped. And of course, the Wilco case has been overruled. And now in the United States, you can arbitrate subject matters arising out of securities law. So this case is presented just to demonstrate some of the arguments in favor of excluding certain subject matters from arbitration. Okay, let's proceed. It's a similar case, but involving the EU competition law. This was in Italy, 1987. This is the decision of July 18, 1987. The Bologna Tribunal. The EU competition law, it's the antitrust law, so we're going to look at the US antitrust law claim under Mitsubishi. So there is a choice of law question here. Okay, which law should you be looking at? Huh? Italian, why? The competing one is French law. Why Italian law?
What is in Italy?
Is it the law of the place where enforcement is sought, or is the place where the tribunal was seated? This is the situation that we have, right? So we have state A and state B. If you have an award that's already issued, the question is how to determine arbitrability, whether the subject matter is arbitrable or not. If you apply state A laws on arbitrability, you might find that it is. If you apply, say, these laws to determine arbitrability, you might find it's not. It's only when the results are different, right? People argue over it. So if you look at the New York Convention, so there's Article 2.3 and Article 5.2a. So what they say here is, if you look at paragraph number 3, in the middle of that, this principle becomes even clearer if Article 2.3 is read in conjunction with Article 5.2a, which subordinates the efficiency of the arbitral award, efficacy of the arbitral award, to the requirement that its subject matter be capable of settlement by arbitration, according to the law of the state where recognition and enforcement are sought. Okay, let's take a look at that particular provision that they're talking about. Article 5.2a. It says, recognition and enforcement of arbitral award may also be refused if the competent authority in the country where recognition and enforcement is sought finds that the subject matter of the difference is not capable of settlement by arbitration under the law of that country. That country refers to which one? The place of arbitration?
Combination court.
Place of enforcement. Right?
Yes.
It is the place of enforcement. So in other words, to have an arbitration agreement enforced, you have to find that the subject matter is arbitrable in not only the place where it's originated, or the seat of the arbitration, but also in the place where it's going to be, it's to be enforced. So the concept of arbitrability is so important that the subject matter has to not only be arbitrable in state A, but it also has to be arbitrable in state B as well. Because what tells us state A is Article 2, right? Each contracting state shall recognize an agreement in writing, whether contractual or not, concerning a subject matter capable of settlement by arbitration. And again, at the very end, Article 5 also says that the subject matter is arbitrable under the place where enforcement is sought. So neither one of these are obligated to enforce something that they don't consider arbitrary. See? That's an important concept. It's not the same about every other thing. The laws could be different, the contract laws could be different, but in this particular case, both A and B, place of arbitration, place of enforcement, I need to consider the subject matter capable of being arbitrated. And ultimately, what they say here is that under EU law, competition law, in any case, the two states should have the same kind of rule on anti-competition. And of course, the most important question is: are the parties capable of agreeing or opting out of this? Can they arbitrate? Can they, by agreement, override public policy? In other words, if the law tells them that it's not capable of being settlement by arbitration, anything pertaining competition law, you cannot arbitrate, can they, by agreement, say, yes, we do? If they say that, could it be enforced? And the answer to that seems to be no, they cannot. They cannot override public policy by a mere contractual relation. So if the subject matter is not capable of settlement by arbitration under the applicable state law, the parties are not free to contract out of it. They are subject to that law. If they make an agreement, nonetheless, their agreement would not be given effect. They cannot have it enforced. The problem with this usually is it's unusual for a state to give you a list of subject matters that are not capable of settlement by arbitration. If a client walks into your office and you're the lawyer and tell you that, oh, we have this arbitration agreement and it's about this and this and about this, that. There is nowhere you can, in many states that I'm aware of, they don't list subject matters that are not capable of being settlement by arbitration. So how do you find if a subject matter is capable of being settlement by arbitration or not? Huh? Precedents, something like that. It's really difficult to find it in one place because it could be about labor law, it's on the labor law. Family law, you have to look at family code or whatever it is. Securities, you have to go to the trade office. So most likely, you need to find some literature, like an article or something that's listing. Oh, by the way, in China, you cannot have trade subject matters, A to Z. This is the list. Otherwise, they are scattered all over different types of laws. They may have specific provisions saying that you cannot subject this to arbitration. You need to make sure that you actually, when you draft an arbitration agreement, among other things, you need to check if that particular subject matter is capable of arbitration or not. A lot of times, in many states, issues pertaining to IP, intellectual property, are not arbitrable. This might be very interesting to young people who are practicing. A lot of IP litigation, things like that, some of them might want to opt out of it. But you need to take that particular jurisdiction. I don't know if you're advising a client who's going to be doing business in Manila, for instance, and they bring you an arbitration agreement and says that we shall arbitrate this IP issue. You need to make sure that in Manila it's going to be enforceable. Just the subject matter itself. It's not enough that the contract looks out very clean. The subject matter could be. These days, the number, yes.
Professor, I'm wondering what about IP transport contract?
Yeah.
Is that suitable for the arbitration?
Yes, you need to check the jurisdiction. That's what I'm saying, because this is very important. Some states they're not allowed. Some states just allow it. Yeah. Some states do not allow franchise agreements to contain arbitration agreements. IP transfer, similarly. So it's not enough that you actually check your own jurisdiction. You must check the jurisdiction of the place where it's likely that you will enforce the arbitration agreement. So if it's a company from Manila and you're in Shenzhen, you have to make sure that it's enforceable here and it's enforceable there. If it's not enforceable there and that's where they have the assets, even if you get an award, they could say no. All right, let's proceed. Sheriff v. Alberto Colder, Supreme Court, 1974. Let's talk a little bit about the facts of this case. Talk about intellectual property. Here it involves a little bit of that. Where did the transaction take place in this case? Vienna, is that the only place? So tell me, who was buying what and where? Who was buying what and where did the transaction take place, like the purchase agreement?
Proto Power Company is buying a company owned by the German citizen. I think the contract is signed in
Vienna.
Vienna.
So for property located where? How many countries are involved in this case?
Germany, England, US,
American one.
How many?
Germany.
5. So tell me all the 5. So this is a U.S. Alberto is a U.S. company, right? Shirk is a German company. And the third one is? Austria, yes. That's where they signed the contract. Okay. What else?
Swiss.
Switzerland, something happened there.
Complete.
So it was all over the place. So this American company, what did they buy?
Trademark.
Trademarks, right? Intellectual property. And what was wrong with that trademark? Okay, it was encumbered. That's what they call it, right? So it was encumbered because third parties had a claim of ownership over this. And that trademark was in Germany, right? The American company wanted to buy that trademark and bring it to the American market. When did they discover that there was a problem with this thing? Later on, right? Significantly later on, they say, you sold us this thing and you knew that it had a problem, but you did not disclose it. Does that happen frequently? Yes, it does. And did they have an arbitration agreement? And the arbitration agreement says what? To arbitrate in Paris. ICC. And does it specify the subject matters that were supposed to be arbitrated? It says nothing about that. If a dispute arises out of this transaction, we shall arbitrate in Paris under ICC. Very common, right? That's what they did. So, relying on Wilco, the American company did what?
Bring us to the court, say the agreement is invalid because it violates the agreement.
So, instead of going to arbitration in Paris, they preferred to bring a legal action in a court of law in the United States. That's why we have a United States Supreme Court case, right? Obviously. So that case went all the way to the Supreme Court for the determination of what particular set of issues. The most fundamental question was about
Whether this kind of contract, the subject matter of this contract is to be arbitrator.
yes. So did the parties disagree that there was an arbitration agreement? No, they did not. But the American company obviously thought that it could disregard the arbitration agreement because the arbitration agreement contained a provision that says that they shall arbitrate a subject matter that's not capable of being arbitrated under what law? It's under, yes, it's under American law. In particular what? Securities Exchange. Exactly. It's under the Securities Exchange Act, 1934. It's an old law. In the Securities Exchange Act, the Securities Act that we discussed earlier in Wilco is designed to protect the standard consumer. Well, companies also buy securities, right? So the buyer is always protected, so they predicated the cause of action on the Securities Exchange Act. And the authority that they cite to is none other than Wilco, exactly, because it had been decided in 1953, and this case was proceeding in the 1960s, probably, too. Maybe 4 or 5 years before it got to the Supreme Court. So under Wilco, the Supreme Court has said that subject matter that is relying on the Securities Act is not capable of being settlement by arbitration. Therefore, the arbitration agreement with Shirk is invalid. We're not going through arbitration. And they initiated the legal action. And of course, when they did that, Shirk had its own lawyers appearing before the district court and telling the district court to do what? Dismiss the case because there is a valid arbitration agreement. So under the New York Convention, Article 3, you must refer the matter to arbitration in Paris. And the other side said, of course, we understand there is a valid arbitration agreement, except that it covers a subject matter that's not capable of being settlement by arbitration, because the Supreme Court has already said under Wilco that matters arising out of securities law, not arbitration. Why? All the reasons in Wilco. Did the Supreme Court agree with the American Parliament? This time they say to. Do you think that this is a change of heart, or the analysis sufficiently distinguishes Wilco from this particular case?
Because Wilco is a domestic case, and this case is an international case.
In fact, the Supreme Court says this is a truly international case. So the distinction between Wilco and Shirk is that this is a truly international arbitration, international case. WILCO is a domestic case. So in international cases, securities laws-based cause of action may be arbitrable because so how is parties' autonomy in international case different from the autonomy that parties have domestically? Does the Supreme Court make itself clear? Why do they make this decision? Why are international cases different from domestic cases when it comes to protection that securities laws provide? Would you think that when you buy securities from another country, you are a lot more vulnerable to be making mistakes? And isn't that exactly what happened in this case? You would have less information, you would have less knowledge of the market issues. Like, it's an American company buying securities in Germany. If you are a Chicago company buying securities in New York, aren't you more likely to have a little bit more knowledge about those things than going abroad and conducting that kind of business? So what is the rationale of the Supreme Court when they say if it is truly international, we're going to allow this thing, but if it is domestic, we're not going to allow it? What's the rationale behind that? It's a pretext for them to be saying yes to arbitration. They found something like domestic versus international. Maybe.
I think that because in international cases, we will face a lot of laws, different countries' laws, and the Supreme Court said we should respect these laws and we should respect the other countries' laws. We will not let every country's cases governed by American law. So the Supreme Court said because we should respect this and because we believe that you are a businessman, you very rational make decisions. So we respect your autonomy.
Yes, I think they think that the ordinary consumer, individuals who buy securities, are assumed to be less sophisticated. But these are big companies doing business on the international scale. So the assumption is that these guys knew exactly what they were doing. They're sophisticated business people, they're conducting business, they were in Vienna, they were in Switzerland, they were in Germany. So these guys really are supposed to know what they're doing. And they are deserving of less protection than the average consumer who buys, a few shares here and there. And secondly, when we talk about international transactions, and arbitration avoids all sorts of jurisdictional problems, choice of law problems, things like that. If you just allow litigation to take place in these kinds of things, it would be endless, right? So they take this famous statement from Bremen v. Zapata. If you look at second full paragraph on page 485. This is really famous. Almost everybody talks about it, and it became this cliche. And it says, we cannot have trade and commerce in world markets and international waters exclusively on our terms, governed by our laws, and resolved in our courts. So you will hear this almost everywhere. And that is what the Supreme Court said back then. The Bremen, interestingly, is not actually an arbitration case. Bremen v. Zapata, it's a 1972 case, right a couple of years before this. It was a forum selection clause. It's a forum selection clause that selected a particular forum in Florida, I think. And the other party wanted to get out of that. That's when they said we cannot have commerce and we should abandon this parochial concept that all disputes must be resolved under our own laws. So when it comes to international commerce, transnational commerce, we should be open to the idea of arbitration outside of our court system. that is really the concept that they try to incorporate here, and they distinguish this case from Wilco, and they say this is a truly international agreement at international, truly international, that's what they call it. That's how they distinguish Wilco from this particular case, and allowed arbitration to proceed, regardless of the allegation that the German party was basically defrauding Alberto when they sold the intellectual property rights to the company. So a 484, second full paragraph, that's where they try to distinguish them. The respondents relies on Wilco in this case ignores the significant and we find crucial differences between the agreement involving Wilco and the one signed by the parties here. Alberto Gomez's contract was a truly international agreement. It is an American corporation, and its place of business, and the vast bulk of its activities is in this country. While Turkey is a citizen of Germany, whose companies were organized under the laws of Germany and Liechtenstein, the negotiations leading to the signing of the contract in Austria and the ongoing closing in Switzerland, and took place in the United States, England, and Germany. Finally, and most significant, the subject matter of the contract concerns the sale of business enterprise organized in the laws and primarily situated in European countries, with activities largely, and if not entirely, directed to European markets. So that's how they basically distinguished these two cases and came to a completely different conclusion.